Hello everybody and welcome back to another episode of Sloth Law. Today we're going to be talking about one of the big cases related to the Commerce Clause, Wickard v. Filburn. Before we begin though, please do me a solid and hit that subscribe button below. And if you like what you see, don't forget to hit the like button. It really does help the channel out, particularly when it comes to meeting new people. So in 1941, the United States was still in the depths of the Great Depression. Things weren't doing so good. Right? Unemployment was high, money was scarce, and to help manage the overall price of wheat in the country, the government ended up passing something called the Agricultural Adjustment Act of 1938. Yeah. This act, in short, set up guidelines as to how much wheat you could grow on your land. This was intended to limit the supply, which would then impact the price, giving the government some ability to try and stabilize that price. Well, Roscoe Filburn had a farm in Ohio at this time, and at the time he was allowed to grow wheat on just over 11 acres of land, which grew about 20 bushels to the acre. He decided, though, to plant 23 acres of land, which resulted in 239 more bushels than he was allowed to grow at the time. The government was not so happy and slapped him with a fine of $117 and a little bit of change. Filburn appealed that fine, alleging that the extra wheat was not intended for market, but for his own use, namely for eating some and the rest to go to his cattle. If that were so, he contended, the excess wheat shouldn't be covered under the act because it wouldn't touch the federal Commerce Clause. Now this is an important point because the federal law has to be grounded and is limited by its constitutional basis, the constitutional powers. The Commerce Clause, found in Article 1, Section 8, generally gives Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Filburn's position was, in essence, that because he would use rather than sell his wheat, there was no trade between the states, therefore no basis in the law to fine him. Unfortunately for Filburn, the court took a very different view of the situation. Directly against Filburn's position, the court found that his own demand for wheat, in the grand scheme of the country, might be a small thing. It might not be a big deal. But if you were to put 1,000 Mr. Filburns together, their demand in total starts to matter and could actually work to affect the price of wheat itself. As a result, every individual has to be covered by the law. The court also found that the marketing quotas set out by the Agricultural Act that got Filburn in the trouble in the first place did not only include wheat for sale, but wheat for consumption as well, whether it was for people or for livestock. In theory, the excess wheat, even if it wasn't going to be sold, could be sold, and therefore it was touched by the quota. The court then went on to greatly expand the scope of the Commerce Clause, stating that the commerce power is not confined in its exercise to the regulation of commerce among the states. It extends to those activities intrastate, which so affect interstate commerce, or the exertion of the power of Congress over it, as to make regulation of that appropriate means to the attainment of the legitimate end, the effective execution of the granted power to regulate interstate commerce. Basically, it's not actually just the trade itself that counts, but things that could impact interstate trade as well. Those things are also then covered by the Commerce Clause. So to figure out when an activity may be or may not be interstate commerce, but still qualifies because it touches interstate commerce, the court came out with a standard that the activity must exert a substantial economic effect on interstate commerce to qualify. In the end, Filburn lost. And this broad reading of the Commerce Clause, that was the law of the land in the United States until the mid-1990s, when a case, United States v. Lopez, happened in 1995. That will be the subject of another video later. Wickard also popped up several other times in the intervening 50 years, including in marijuana prosecution cases in Gonzalez v. Raich, as well as the Affordable Care Act in debating the constitutionality of individual mandates in 2012. Judge Jeffrey Sutton of the Sixth Circuit went on to say if, as Wickard shows, Congress could regulate the most self-sufficient of individuals, the American farmer, when he grew wheat destined for no location other than for his family farm, the same is true for those who inevitably will seek health care and who must have a way to pay for it. But, as we all know, lawyers do love to argue, yet 3 lawyers together and 5 different opinions. 2 judges from the 11th Circuit saw it differently. Wickard is striking not for its similarity to our present case, but how different it is, Judges Joel F. Dubina and Frank Hull wrote in discussing the Affordable Care Act. To make their point abundantly clear, the judges wrote, individuals subjected to this economic mandate in the healthcare law have not made a voluntary choice to enter the stream of commerce, but instead are having that choice imposed upon them by the federal government. But again, the Affordable Care Act is a video for another day. So I hope you enjoyed this video, and if you did, please remember to comment below and hit that like button. And one more thing too. If you've got a spare minute, you should go and check out the photographers over at Unsplash. You can see some of the links below. They've got a ton of great photos from some seriously talented people, and a lot of the images that you see in this video come from those individuals. Now, I am not sponsored, quite obviously, by Unsplash, but it's true nonetheless. You should go give them a look, give them a little bit of love. They have a lot of talent over there. So, until next time, have a good night, everybody.